Speaking at the felicitation program organized by the Association of Indian Americans in San Francisco on 2nd July 2022, Chief Justice of India N.V. Ramana asserted that the judiciary is answerable only to the Constitution. The general population of India was blamed by the Chief Justice for their lack of understanding about the Constitution and the functioning of the democratic institutions. In order to safeguard the checks and balances envisioned in the Constitution, the Chief Justice emphasized on promoting the constitutional culture in India. The US was praised by the Chief Justice as the nation which honors and respects diversity, which made it the successful nation it is today. The tolerance and inclusive nature of American society were appreciated as the reasons why USA attracts the best talents from all over the world. The Chief Justice added that the principle of diversity needs to be honored everywhere in the world, including in India. While drawing parallels between the USA and India on the lines of democracy and constitutional values, the latter faced many criticisms. What must be noted is that the US, which got praised by the CJI, involves the Senate of the United States Congress in appointing judges. Public hearings of the potential candidates are conducted by the Senate Judiciary Committee in the US before confirmation of the candidates. However, in India, the National Judicial Appointment Commission, introduced by the central government in 2014, was struck down by the Supreme Court in 2015 by declaring it as unconstitutional. Allegations were made that this commission was seen as an obstacle which would harm the nepotism prevalent in the judiciary. The collegium system of appointing the judges in India is often blamed as an undemocratic process which lacks transparency. As per reports, almost half of the judges in the Supreme Court are said to be directly related as family members to those occupying higher positions in the judiciary. The collegium system was defended by the Chief Justice in April 2022 by claiming that it is democratic. The fact that the Chief Justice comes from the land which has honored religious pluralism and diversity for thousands of years was somehow forgotten. The Hindu ethos of giving shelter to the persecuted made India the home of persecuted people from across the world for centuries. The Zoroastrian ancestors of Chief Justice's colleague Justice Pardiwala and former Supreme Court Judge Rohinton Nariman, who fled Iran after the Islamic conquest in the 8th century, prospered in India without any fear of persecution. The Hindu nature of inclusiveness and tolerance made India a safe place for the Jews to reside without any fear of anti-Semitism throughout centuries. India has a rich history of multiple kinds of judicial systems which sustain the Indian society for thousands of years. From Apastamba Dharma Sutra to Arthashastra of Kautilya, the Hindu civilization has a rich heritage of legal texts discussing the topic of governance. The concept of Rajdharma, dealing with how a king is supposed to rule in a virtuous way for the welfare of his subjects, is an integral part of Hinduism. However, such deep and genuine understanding of dharma and its principles of justice is lacking in the current judicial structure. Even after more than 7 decades of the end of British rule, the entire proceedings of the apex court are done in only English language. The thought process of the privileged elites of India who dominate the establishment is entirely colonized regarding their nation and civilization. The cultural illiteracy of the colonized judiciary in context of Hinduism and using Abrahamic theological terms to define Hindu institutions has been used to deny Hindus their core rights. As a result, those who are at the helm of judiciary often end up criticizing the general population of India without understanding the indigenous context, like in the case of Sabrimala. Article 26 of the Constitution, which gives freedom to establish and maintain institutions for religious and charitable purposes, has been used to deny the autonomy to Hindu temples as they do not fit the Christian definition of the term denomination. The same Article 26 has been used to give autonomy to Christian and Muslim religious institutions. Hindu Sampradayas are not accepted as equivalent to the denominations by the Indian judiciary, as seen in the Sabrimala case when the 5-judge bench refused to see the issue as one involving a denomination. The Constitution of India is a document which has borrowed more than half of its content from the Government of India Act, which was enforced by the British government in 1935. Claiming to be the custodian of the document inspired from the act implemented by the alien imperialists is equivalent to defending colonialism. imposing the notion of constitutional patriotism on Indian society based on the document lacking Hindu cultural and civilizational experience and disrespecting the native cultural values due to the colonial thought process only widens the social divide. Instead of constantly seeking inspiration from the Enlightenment ideas of Europe, it's the need of the hour to introspect and revamp the judicial system of India rooted in the native Hindu values. This is something which various judicial personnel themselves have asked for in the past, including the Chief Justice.